Hello and welcome to the DPIIT-IPRCHAIR IIT Roorkee's YouTube channel. Today we are going to discuss an important case decided by the Delhi High Court which deals with trademark infringement, copyright violation and passing off. The case is titled as Spota Technology Private Limited versus John Doe and others. The case is decided on 4th November 2024. The background of the case is the Spota Technology Private Limited is the company behind the very popular fantasy sports platform, which is called Dream11. It allows users to create virtual teams made up of real players from cricket, football, kabaddi, and other sports. These teams score points based on how the actual players perform in real matches. Dream11 has over 20 crores users in India alone and is an official partner of many major sporting events, including the IPL through a deal with the BCCI. Because of this popularity, Dream11 has become a well recognized and trusted brand. So in December 2023, Dream11 discovered a fraudulent website running in the domain name dream11lottery.com. This website was pretending to be the real Dream11 platform. It used the word dream, the full name Dream11, and even an email ID, which is admin@dream11.com to mislead the public. Basically, this fake website copied the look and feel of Dream11 to fool the users. It was tricking people, possibly collecting their personal data or money while pretending to be Dream11. The person or persons behind this fake website were unknown. That's why the case is against John Doe, which is a legal term used when the real identity of the infringer is unknown. So now come the key issues. The issues involved in trademark infringement, passing off, and the unauthorized use of copyrighted content and domain names. The plaintiff argued that the defendant number one's action were intended to mislead consumers into believing an association with the plaintiff's renowned fantasy sports platform, that is Dream11. So the Dream11 immediately took legal action. They filed a lawsuit before the Delhi High Court, and the grounds were the infringement of registering trademark, passing off, infringement of copyright, damages and compensation, and also they wanted the infringing material to be handed over or it should be destroyed. They also wanted the court to block or suspend the fake website. So legal proceedings started, and the plaintiff alleged that defendant number one adopted and used marks such as Dream and the domain name Dream11lottery.com, which closely resembled their trademarks and website features, leading to confusion and misrepresentation among the public. An interim injunction was initially granted in favor of plaintiffs, restraining defendant number one from using their marks pending further proceedings. Then the nature of dispute is centered on the unauthorized replication of the plaintiff trademark name and website elements by defendant number one, allegedly to attract traffic and business under false pretenses. So the claim which the parties asked infringement of trademark, registered trademark from plaintiff side, and the violation of copyright, passing of services, and domain name misuse. And defendant number one, who is John Doe, the unknown person running the fake website dream11lottery.com, and the defendant number two, the domain name registrar who has registered the name, the company that provided the domain name to defendant number one. The court sent notices to both the defendants. However, neither of them replied and no written statement were filed. This allowed the court to proceed ex parte, which means the case moved forward without the presence of the defendant. Then Honorable Justice Mini Pushkarna heard the case on 8th January 2024. The court passed an interim order which immediately stopped defendant number one from using any mark or a name similar to Dream11 directed defendant number 2 to suspend access to the fake website, asked the domain registrar to reveal the identity and contact details of the person who had registered dream11lottery.com. Later, when the defendant failed to appear or present any defense, the court relied on Order 8 Rule 10 of CPC, Civil Procedure Code, which allows a court to proceed when the opposite party does not reply. Then Justice Pushkarna said that recording further evidence would be a waste of time as the available evidence was enough. Then Justice Mini passed a final judgment on 4th November 2024 and held that defendant number 1 was infringing the registered trademark Dream11. They were also passing off and misleading users. The domain name dream11lottery.com was deceptively similar to the real domain dream11.com. The email ID admin@dream11.com used by the infringer also created confusion and violated copyright. So the court issued a decree in the favor of plaintiff, granting a permanent injunction, damages, and cost against the defendant number 1. Nominal cost of rupees 1 lakh is awarded in favor of the plaintiffs to be payable by defendant number 1 till January 2025. So this is very important example of how court in India are actively protecting brand owners from online fraud and misuse. It also shows the value of registering your trademark, the importance of acting quickly when you find someone copying your brand, how courts can use John Doe orders when the infringer is unknown, the role of domain registrar in preventing misuse of domains. So this is a victory not only for the Dream11 but also for all businesses and startups who are trying to build a trusted digital brand. So I hope you now clearly understand this important judgment. If you found this video helpful, don't forget to like, share, and forward this informative video. And stay tuned with us. Thank you.